All rise for the Honorable Judges of the Caribbean Court of Justice.
Can you all please take your seats? Thank you.
Well, before we call the Moot case, can I welcome everyone here, and particularly the Mooters, of course. I also recognize that we have Sir Dennis Byron here, and the Chief Justice Ivor Archie, and I believe Mrs. Miriam Samaru. So welcome to you especially. So best of luck to you Mooters. Remember, of course, you've got 20 minutes for senior counsel, 15 minutes for junior counsel. When there's a yellow card presented, you've got 3 minutes left. When there's a red card presented, you've got no time left, except in my discretion, I may give you a little extra if particularly my two fellow judges have been asking you too many questions, so you haven't been able to get on with your case as well and as quickly as you like. Meanwhile, I think we can in a position now to begin the moot, so can you please call the moot? Thank you.
Suriname and Barbados, can we please have all appearances? Thank you.
If it pleases this honorable court, my name is Danielle Phillips, and I appear as senior counsel on behalf of the Republic of Suriname. Appearing alongside me is junior counsel, Mr. Kai Bridgewater, and our researcher, Mr. Zachary Phillips. I'll now hand over to my learned friends on the other side to introduce themselves.
If it pleases this honorable court, I am Arthur Thomas, representing the state of Barbados and from the Hugh Wooding Law School. And I'm joined by my junior counsel, Michael Monroe, and we're ably instructed by Roger Hector.
Right, thank you. Thank you. So, Ms. Phillips, you'd like to come to the podium and present your case. Yes, Ms. Phillips.
If it pleases this honorable court, once again, my name is Danae Phillips, and I appear as senior counsel on behalf of the Republic of Suriname, the claimant in this matter. Your Honor, before I begin my substantive submissions, I'd like to outline that the case before you today concerns a CARICOM national, Mr. Boston Bent, who has suffered breaches under the RTC as a result of the actions of the state of Barbados. As such, I'll be making two submissions. My first submission is that Barbados breached the principle underlying Article 223(2) of the revised Treaty of Chaguaramus, hereinafter referred to as the RTC. And my second submission is that Barbados also breached Article 8 of the RTC by refusing to register the judgment of Mr. Bent. In respect of my first submission, I will be making 3 points. Firstly, I will outline what the principle underlying Article 2232 of the RTC is, and I will also outline how this principle was determined, as well as how Barbados breached this principle. Firstly, Your Honor, we submit that the principle underlying Article 2232 is that access to justice for parties to commercial disputes must be facilitated, as this will serve to further the object and purpose of the RTC. And we submit that not only does access to justice involve being able to initiate a binding form of dispute settlement, but it also involves being able to effectively participate in these proceedings, as well as being able to enforce or benefit from the award that you receive at the end of these proceedings.
So you're saying if mere arbitral awards can be enforced, surely proper legal judgment should be enforced by this registration method.
Our submission is that particularly where the judgment concerns a commercial dispute, then this should be enforced.
We understand why it might be desirable to enforce it, but you are saying something more than desirability, you're saying that there is an obligation to enforce it.
Yes, Your Honor,
How
that
do
is
you,
our
how do you
submission.
arrive at that obligation, legal obligation?
Well, Your Honor, the first point of duty is to look at what the object and purpose of the RTC is. And this honorable court, in the case of Trinidad Cement Limited and TCL Guyana Incorporated, and the state of the Cooperative Republic of Guyana, outlined that the object and purpose of the RTC essentially is to foster regional economic integration. And this will be done by the establishment of the CSME, which was intended to be private sector driven. And we submit that Mr. Bent, as well as Rock Exporters Limited, the persons with whom he was involved in the commercial dispute, they would essentially form a part of the private sector.
So that is the basis on which you say there is this obligation. I mean, if you read 223, it is clear that if this was, in fact, an arbitral award, there would be an obligation. Right. There is no arbitral award here. There is a judgment given. So how are we to say that there is a similar obligation to enforce this foreign judgment as there would have been had it been, in fact, an arbitral award? I'm not sure you have convinced me yet that there is a legal imperative that forces me to order the enforcement of the foreign judgment.
Well, Your Honor, we submit that the provision in the RTC specifically provides for arbitration because the framers of the RTC recognized that international commercial arbitration was being increasingly utilized to resolve commercial disputes, which falls within the ambit of what the RTC envisioned would have arisen as a result of increased intra-regional commerce.
So are you saying that they were nearsighted?
Pardon me?
Are you saying they were nearsighted? So they could only see arbitration, they couldn't see that judgments also might need to be enforced?
Well, Your Honor, we're not in a position to say what they saw or didn't see, but we submit that the reason that they specifically provided for arbitration was because of its increasing popularity and because the judgments ordinarily fell within the ambit of state law, and they would have already had legislative procedures that provided for the enforcement of judgments, which would span the broad spectrum of litigation and not just commercial disputes.
I follow. So maybe then they were content to rely upon those other arrangements that they had for the enforcement of the judgments, and not to say, well, look, the judgments must be brought within the scope of 2232.
Well, Your Honor, it would be our submission that if the court is to adopt a teleological approach, then the application of Article 2232 can extend to judgments. Your Honor, may I be permitted to recommence my submissions?
Certainly.
Very well, Your Honor. We submit further that Your Honor, that if parties to commercial disputes do not have access to justice, this would essentially mean that the dispute wouldn't have been resolved effectively.
But you're putting up a straw man there, aren't you? Why are you saying they don't have access to justice?
Because, Your Honor, as we submitted before, access to justice involves being able to benefit from your award that you receive at the end of the commercial dispute. And in respect of this particular case, Mr. Ben wasn't permitted to benefit from the award that he received, because it's all good and well that you can go to the court or you can use arbitration to resolve your dispute. But if at the end of the day, you aren't able to benefit from the award that you received, then essentially the proceedings...
We can benefit from it via the common law method, can't he? You can bring an action for a summary judgment based upon the clear judgment you've got, res judicata, so you're bound to get judgment in default of defense in due course. Is that not enough? Why do you want to say you need a right to register?
Your Honor, I'm not sure I understand the question. Could you rephrase it for me, please?
Well, you have access to justice by virtue of the fact you can, at common law, go to the court and get a summary judgment without a full trial by saying, look here, in my home jurisdiction, I got a judgment, res judicata, a clear debt of a certain amount. So you then come to a country like Barbados and say, here I am, I've got a clear established debt, not denied, res judicata, so I want judgment in default of defense, or in default of appearance, if there's no appearance, of course. And so that gives you access to justice. But you seem to be saying that's not enough. I assume you were talking about the need simply just to be able to register your judgment for a debt of a certain amount, and it thereby becomes enforceable without more.
Well, Your Honor, it is our submission that notwithstanding that Mr. Bent can utilize this common law procedure to enforce his judgment, it is more onerous to utilize this method of enforcement. And we submit that the issue, because it has to do with a commercial dispute, brings it within the remit of the RTC. And this honorable court is empowered to rule on matters that can touch and concern the interpretation and application of the RTC based on Article 211 of the RTC.
Why do you say it's more onerous to go the route of the common law?
Because, Your Honor, essentially, if he was to go about utilizing this common law method of enforcement, it would be as if he was commencing entirely new proceedings based on how it's...
No, these are summary proceedings, as the President just indicated. These proceedings tend to go through very, very easily, very quickly. Often they're not even contested. There's a debt established already by the courts in Suriname, and you're simply bringing that into the legal system in Barbados. So,
well, Your Honor, it is our submission that it is in fact more onerous based on the fact that the requirements under this common law procedure for enforcement require him to prove far more than he would have been required to prove if he was to seek enforcement under the Barbados legislation.
so it is less favorable treatment.
It's less favorable, yes, Your Honor, that's our submission.
Even if going at common law wasn't difficult, your point still holds because it's less favorable than going under the registration regime.
Essentially, Your Honor.
Yeah, okay.
Your Honor, we submit that upon examining the object and purpose of the RTC, which is essentially to foster regional integration through the establishment and the proper functioning of the CSME, if parties to commercial disputes weren't able to effectively resolve this dispute, this would lead to the hampering of the advancement of the CSME. Therefore, persons both within and outside of the region wouldn't be encouraged to participate fully in the CSME so that the purpose of the object and purpose of the RTC couldn't be furthered, essentially. Additionally, Your Honor, upon examining Article 2232, Article 223 in its entirety, we see that essentially paragraph 1 encourages or requires that member states encourage their nationals to resolve these commercial disputes by the utilization of arbitration as well as other modes of dispute settlement. Paragraph 2 goes on to outline or mandate that member states must ensure that they have appropriate procedures in their legislation that would ensure the observance of agreements to arbitrate, as well as the recognition and enforcement of arbitral awards. Paragraph 3 goes on to give examples of satisfactory compliance with paragraph 2, as it outlines that any state that has implemented either the UNCITRAL arbitration rules or the New York Convention on the recognition and enforcement of foreign arbitral awards would have satisfactorily complied with paragraph 2. And when you examine both these treaties, you see that they provide for how arbitration can be commenced, how the proceedings should be conducted, and how the award can be enforced. This would therefore be an example of what an appropriate legislative procedure would be. Additionally, they focus on harmonization and unification of the laws in relation to international commercial arbitration. And this is beneficial because it would facilitate access to justice in the sense that a party's claim wouldn't be frustrated by something like the country in which they seek to enforce their arbitral award.
Now, is harmonization also one of the objects of the treaty?
It could be implied, Your Honor, but I don't know if we can definitively say that this is the object and purpose of the treaty, because based on the mere fact that the article doesn't require that member states implement these legislations, we submit that these international treaties give examples of what appropriate legislative procedures would be.
You're not arguing that Barbados has breached that obligation, are you?
No, Your Honor.
Okay.
Going back to paragraph 1 of Article 223, the fact that member states aren't required to mandate that their citizens or community nationals utilize arbitration or other modes of dispute or alternative modes of dispute settlement suggests that if a party opts to use the traditional court system, rather, pardon me, Your Honor, it does not preclude persons from utilizing the traditional court system to resolve their dispute. And we'd just like to highlight that Sir Dennis Byron, in an address he gave on perspectives on the relationship between arbitration and the courts, outlined that access to justice is not facilitated only by traditional court systems. It applies equally to arbitration and the other forms of dispute settlement.
Was he speaking judicially or otherwise?
No, he wasn't speaking judicially, but we...
Why do you raise it? I mean, what weight would that have with us now?
Well, Your Honor, we submit that the court might find this persuasive in light of the fact that he's a recognized jurist and his opinion would be indicative, essentially, of the opinions of the court. Now, albeit in an unofficial capacity.
I see.
Yeah. But coming back to Article 223, the fact that it refers specifically only to arbitral agreements indicates it wasn't intended to cover legal judgments, just arbitral agreements, surely. Is that not an argument that we have to face?
Well, Your Honor, though it explicitly provides for arbitration, we submit that the reason that it specifically provided for arbitration was because of its increasing popularity or use to resolve the international commercial arbitrations. So they wanted to ensure that should parties utilize this increasingly popular method of dispute resolution, that appropriate procedures would be in place for them to conduct the proceedings.
Or is it so logical that you should be able to enforce judgments that you don't even have to mention that?
Well, Your Honor, that is a possibility, but we're not in a position to definitively say that that is the case.
Well, anyway, they didn't say it. The treaty doesn't say so. But you are implying a right, so.
Yes, Your Honor.
And I suppose they had to do something about arbitral agreements because they were all parties to the 1958 United Nations Convention.
I'm sorry, Your Honor, I didn't hear the first part of your question.
Yes. You could argue that the reason why it dealt only with arbitral disputes was that the parties, the states parties, were party to the UN Convention on arbitration and recognition of arbitration judgments. So they had to deal with that in the treaty.
That is an argument that could be made, Your Honor. However,
Are you making it?
not entirely, Your Honor.
Not entirely.
No.
So to what extent do you make it?
Well, our submission or our position remains the same, that notwithstanding that is a reason that they would have included it, it could also have been that arbitration, international commercial arbitration, because it was relatively new and also because many of the legislation in the Caribbean that related to arbitration was outdated. Because you see that states like Barbados in 2007, they incorporated the UNCITRAL arbitration rules, as well as Jamaica. They recently just incorporated the UNCITRAL arbitration rules.
And what about Suriname?
Suriname, Your Honor, we, or submission or our position remains the same, that notwithstanding that is a reason that they would have included it, it could also have been that arbitration, international commercial arbitration, because it was relatively new and also because many of the legislation in the Caribbean that related to arbitration was outdated. Because you see that states like Barbados in 2007, they incorporated the UNCITRAL arbitration rules, as well as Jamaica. They recently just incorporated the UNCITRAL arbitration rules.
And what about Suriname? which you are representing.
Yes. As far as I'm aware, I do submit that Suriname has incorporated the UNCITRAL arbitration rules.
Anyway, you want to move on from Article 223.2?
Article 8, huh?
Pardon me?
Do you want to move on from Article 223.2 that we've just been mentioning?
Yes, I'd just like to wrap up my first submission, Your Honor. So in a sense, Barbados breached the principle underlying Article 2232 because in refusing to register the judgment of Mr. Bent, he wasn't able to benefit from his arbitral award. Now, if the court has no further questions, I'd like to move into my second submission, which is that Barbados, by refusing to register the judgment of Mr. Bent, breached Article 8. Now, Article 8 of the RTC requires that in respect of a right by the treaty, no member state shall accord to another member state or a third state any treatment that is less favorable. As such, I'll be addressing my submission in 2 points. Firstly, I will be illustrating that there is a right under the treaty that inures to Suriname and by extension Mr. Bent's benefit. And I will also be outlining that the treatment in respect of this right was less favorable than that which was accorded to Mr. Bent. Essentially, this honorable court in the previously mentioned case of TCL and Guyana outlined that rights under the treaty aren't always expressed. They can be inferred from obligations. And 2232 imposes an obligation on member states. But we submit that a correlative right does attach to 2232, and this correlative right would be the right to appropriate procedures in legislation that would enable a party to enforce their arbitral award. However, we do submit, Your Honor, that this would arise on a textual interpretation of the provision, and this would be insufficient as it precludes this particular provision from applying to judgments.
But
So you're
what
going to,
does this right correlate? It's a correlative right, but what does it mirror?
It mirrors the specific provision in Article 2232, because Article 2232 mandates that member states implement appropriate procedures in its legislation that would ensure the observance of agreements to arbitration and for the recognition and enforcement of arbitral awards, pardon me. Therefore, the mirrored correlative right would be the right to these appropriate procedures.
well,
So
it's not a very accurate mirror though, is it? Because if you were to look at, is it 82 that we discussed in the TCL case, where we said that there's an obligation on the state to impose and maintain the CET, and then there's a right, a correlative right, which inures to the benefit of a private person to the benefit of the CET. So there's a direct relationship between the obligation to maintain the CET and the right to benefit from the maintenance of the CET. Now with 223, it's very, very different. 223 has to do with perhaps obligation to enforce arbitral awards. So I would say that the correlative right to that would be the right in the private citizen to make sure to have his arbitral awards enforced. So aren't you going beyond the scope of TCL when you ask us to infer a right not based on an obligation to enforce foreign judgments, but based on an obligation to enforce international arbitral awards?
Well, I'm guided, Your Honor.
Well, I'm not hoping to guide you. I'm hoping to ask you what your view is. And aren't you suggesting that we should go much further than we did in the case of TCL?
Well, I'm not sure I would say that you would be required to go much further than you went in TCL, Your Honor. But we submit that if this honorable court is to interpret Article 2232 in a manner that does not defeat the object and purpose of the RT3, then necessarily you would need to extend its application to judgments that have been handed down at the end of a commercial. Your Honor, I see that my...
Yes, in view of the questioning you have another 3 minutes, thank you.
Yes, Your Honor. We submit that if the court is to give effect to the object and purpose of the RTC, then Article 2232's application must extend to judgments given particularly for commercial disputes, Your Honor. And that again is based on the judgment in the case of TCL and Guyana.
Why limit it to commercial judgments? Why not go the full hog?
Because Article 2232 was very specific in being in relation to 223, in being related to commercial disputes. And Mr. Bent himself, it's inferred that he was a party to a commercial dispute, as the other party in the matter was Rock Hard Exporters Limited, a Barbadian company. We submit, Your Honor, that additionally, there is a sufficient nexus between arbitration and litigation based on the fact that the principle which underlies Article 2232, which applies to arbitration, applies to all forms of dispute resolution, of which traditional court systems and arbitration are part. Therefore, we would submit that the right that inures to Mr. Bent's benefit is the right to have appropriate procedures in legislation that would enable him to enforce his judgment from the commercial dispute. In respect of the less favorable treatment, Your Honor, we submit firstly that the case of Shanique Mary highlighted that most favored nation treatment is a manifestation, albeit a limited one, of non-discrimination. Therefore, we submit that an equality of treatment is essentially what is achieved, but we do accept that a difference in treatment, as is the case under the Barbados legislation, does not automatically equate to discrimination. However, we submit further that the less favorable treatment arises when you examine that there are additional requirements for non-Commonwealth nationals or non-Commonwealth persons seeking to enforce their judgments under the Barbados legislation when compared to Commonwealth states. Additional, and that would have been found in Section 8.2 of the legislation. Additionally, though the legislation in and of itself is not discriminatory, we submit that discrimination can be inferred on a de facto basis.
We've got 1 minute left.
Because, Your Honor, persons who are from St. Lucia and Jamaica, both CARICOM states, as well as Nigeria, which is a state outside of CARICOM, all these persons are able to benefit, while Surinamese nationals, like Mr. Bent, none of these persons are currently benefiting under the Act. It is on that basis that we submit that the treatment meted out to Mr. Bent is in fact less favorable. Your Honor, unless you have any further questions.
Earlier we heard from another source, perhaps, that there might be a problem registering the judgment in Barbados. And that problem is that the time to enter an appeal against the Suriname judgment has not yet expired. Until the expiry of that time, that judgment can't be registered. Perhaps in your reply, you may wish to address us on that point.
Well, Your Honor, our submission...
Unless you wish to do so now.
Give it in your reply.
You don't reply to that specific question?
No, you have a 5-minute right of reply at the end, so you can deal with that issue then.
Guided, Your Honor.
Thank you.
Unless you have any further questions for me, these are my submissions.
Right, thank you very much then, Ms. Phillips. So, Mr. Bridgewater. In a hurry to get there. He wasn't in a hurry to get there. Yes.
May it please this honorable court. My name is Kai Bridgewater, junior counsel appearing on behalf of the claimant, the Republic of Suriname. And in my submissions, I shall be elaborating on how Barbados has breached 1. Article 7 of the revised Treaty of Chaguaramas, the right to non-discrimination, and 2, its international obligations stemming from the revised treaty. In substantiating these submissions, I shall, one, in relation to the first submission, which is that Barbados has breached Article 7, the right to non-discrimination by preventing Mrs. Bent to be able to be registered to vote under the same requirements as CARICOM citizens from Commonwealth states. I will, one, outline that Article 7 is not a standalone right. Two, I will outline that the right it attaches to is the implied right to vote, which exists as a necessary corollary of the right under Article 46, the right to movement of skilled nationals. And finally, that it satisfies the test elucidated in Myrie versus State of Barbados for discrimination under Article 7. Article 7, Your Honor, it is an obligation on member states not to discriminate against other member states or their nationals within the scope and application of the treaty on the basis of nationality only. Now, although this article is of paramount importance, the court in the case of Cabral, Douglas, and Dominica outlined it is not a standalone right. It is a right that it...
I'll ask you something, because you're saying, I always thought that Article 7, discrimination, that is about you should not treat nationals of other member states differently from your own nationals. Is that the case here?
Your Honor.
Well, of course, nationals, Barbadian nationals can vote for their parliament.
Your Honor.
Or is it that you more look at a comparison with nationals of other member states who apparently have the right to vote under certain conditions, but not those from Suriname? There's a difference between 7 and 8 here, but...
I agree there is a difference between 7 and 8, although this court in Myrie versus State of Barbados outlined that 8 is a manifestation of Article 7. However, to respond to your question, we submit that we are not seeking to submit that that nationals of Suriname be able to vote on the same requirements as Barbadian citizens, but rather that the nationals of Suriname, a CARICOM non-Commonwealth state, should be able to vote on the same requirements as citizens of CARICOM states from CARICOM Commonwealth states, Your Honor.
To make it a little more precise now, suppose the legislation of Barbados would only allow nationals of Barbados to vote, nobody else. Would you still have a case?
Your Honor, it is submitted that there is still a case.
Or is it because Barbados gives this right under certain circumstances to non-Barbadians who are Commonwealth citizens?
Thank you very much for your question. I'll answer it in two parts. One, it is submitted that they would still have an implied right to vote, as it is a necessary corollary under Article 46, as Article 46 would be meaningless or of considerably less value without it. However, Your Honor, we submit that the case before this court
is that... Would it be meaningless?
Or, well, it is the test as elucidated in Cabral Douglas was that the primary right would be meaningless or of considerably less value without the implied right. And we submit that the right to vote is, without the right to vote, the right under Article 46, the right for free movement of skilled nationals, would be of considerably less value. And to finally wrap up your question, I submit to this honorable court that the case before this court is that Barbados has imposed a residency requirement for voting for CARICOM Commonwealth citizens, while for CARICOM non-Commonwealth citizens, they would have to wait 7 years to be able to vote, as they would have to become naturalized under Section 7 of the Citizenship Act. And this difference of 4 years is worse or less favorable treatment within the scope of the revised treaty, as outlined in the case of Myrie, as the test for discrimination. But with that being said, Your Honor, I would like to outline to this court why Mrs. Bent is exercising, or show this court that Mrs. Bent is exercising her right under Article 46 of the revised treaty. Now, Article 46 imposes an obligation on member states to accord to certain categories of community nationals, such as university graduates like Mrs. Bent, the right to seek employment in their jurisdiction. The Caribbean Community Movement of Skilled National Act, as of Barbados, can be seen as a municipal incorporation of this to give effect to the provisions and obligation that stems from Article 46. This is evidenced by its long title, which states it is an act to remove the restrictions on entry of CARICOM skilled nationals from qualifying Caribbean community states pursuant to Article 46 of the revised treaty.
So you're commending Barbados, aren't you?
Pardon me, sir?
You are commending Barbados.
I'm definitely commending them, and
They have lived up to their treaty obligation.
Pardon me, Your Honor?
They have lived up to their treaty obligation. That's what you're saying.
Yes, sir. Yes, I am, Your Honor.
Okay.
And that by virtue of Mrs. Bent, which the facts have indicated, has moved to Barbados to take up employment as a professor at a local community college, pursuant to Section 4 of the aforementioned Act, which states that these persons are entitled to indefinite entry, we submit that she is clearly satisfying she satisfied the requirements under Article 46 and is therefore exercising her right under Article 46, the right to move in for free movement of skilled nationals lawfully.
But you really should be now, and so,
pardon me,
why she has a right to vote, but I don't see that yet.
Yes, Your Honor. So, and we shall now segue into why the right to vote is a necessary corollary of this right to free movement of persons. We submit to this honorable court that implied rights have been propelled to the forefront of the regional agenda. And this was seen in the 39th meeting of the Conference of CARICOM Heads of Government, where the protocol on contingent rights was open for signatures. And since then, it has been signed on to by all contracting parties to the CSME, which includes Barbados and Suriname.
So you're going to point us then to a provision in the protocol which gives her the right to vote, right?
Your Honor, it is submitted that although the protocol does not explicitly list the right to vote within Article 2 and 3, the Protocol 1 in Article 4 outlines that the rights listed in the protocol are not the only contingent rights that exist. And once we look at the definition for contingent right as elucidated in the protocol, we can see that the implied right to vote is an additional enforceable right that is there to support, that stems from the exercise of a primary right, the right to movement of
really,
nationals.
if we follow the logic of your argument, all that the heads would have had to do at most is to enumerate one right, have that preambular statement, and then it will be up to us to then divine all of these other contingent rights from that statement?
Your Honor, it is submitted that it is the object and purpose of the protocol is to be instructive, and that this court in adjudicating on its provisions shall be guided by the object and purpose of the protocol, which is, as I outlined before, to provide additional enforceable rights to support the primary rights provided in the revised treaty.
So what they did then were mere illustrations of what the contingent rights are, and then we can fill in the blanks as we go forward. Right?
Your Honor, it is submitted that Article 2 is not a mere illustration, but rather it provides a list that are to be enforced with the article once the protocol comes into force. However, Article 3 outlines the prospective rights that are to be incorporated over time, and Article 4 outlines that these rights are not exhaustive. Therefore, we submit that it is within the court's purview to find additional rights. However, this is not the extent of our argument.
Did they say that in the protocol? That it was within the purview of the court to find additional rights?
Your Honor, it is submitted that this very court has been able.
I am trying to get an answer from you. Did they say in the protocol that it's within the ambit of this court to enumerate further contingent rights?
Your Honor, it is submitted that the protocol does not state this. However, we believe that it is within this implied right to vote is within the scope and application of the treaty, and is to be considered an implied right that is contingent on the right to Article 46, regardless of whether it is explicitly stated in the protocol. It just shows the intention of the Conference of the Heads of Government, the primary organ of CARICOM, to provide additional enforceable rights to the citizens. We submit that this position regarding...
Aren't you vesting us with too much power?
Thank you very much for your question, Your Honor. We submit that it is not providing the court with too much power, but it is allowing the court, which is the body that has compulsory of an exclusive jurisdiction, the ability to shape the direction of the Caribbean community. And this is a power that was conferred on it within the revised treaty of Chaguaramas.
But surely it's not an unrestricted power.
Yes, Your Honor, we submit it is not unrestricted.
Okay,
However,
so where is the restriction?
pardon me, Your Honor?
Where is the restriction? For example, because we could read all kind of rights into this treaty. The right to life, is that a right under the treaty?
Oh, yeah.
But if you don't live, you cannot move. And the right and freedom of movement is a right. So if you take that kind of reasoning, then it never ends. So where is the limit?
Well, Your Honor, it is submitted that the General Exceptions Article, Article 226, provides for states to enact measures that should not be considered to be inconsistent with the treaty once they're objective and reasonably not arbitrary. However, objectively reasonable and not arbitrary. However, Your Honor, we submit that this very court has outlined how much they will imply a right within the RTC. And this is the same test that was elucidated in Cabral Douglas, where the court outlined that for an implied right to be conferred, the primary right must be meaningless or of considerably less value. And now we submit to this honorable court, as was outlined in an article by Michelle Fink, that by preventing migrant workers from voting, you are likely to affect them socially and negatively adversely. And so we submit to this honorable court that persons who are moving to carry out economic activities in other member states are likely to be extremely sensitive to economic realities. And therefore, Your Honor, by eroding their ability to have a say in the persons who will form tax legislations and which will affect them economically, you are considerably eroding the value of that right under Article 46.
So let's have a look at another community, the European Union, which we all know is a little further with integration than the CARICOM. So does that right exist that you can vote for the parliament in the country where you are, which is not your own country? Does that right exist?
Your Honor, thank you very much for your question. We submit that the right to vote does exist within the European Union, within Article 22 of the Treaty on the Functioning of the European Union. And prior
Vote for what?
Pardon me?
Vote for what?
You are able to vote for European elections as well as municipal elections in other member states by virtue of your citizenship as a European national.
But not for your national parliament.
Your Honor, it is submitted that although you may not vote for the national parliament, or it's not specifically outlined that you may be able to vote for your national parliaments of other member states in the TFEU, it is submitted that it is something that has been heavily debated within the European Union. And this was an example of this is in the referendum on Luxembourg, and the Vice Prime Minister of Luxembourg stated within this referendum that it only seems logical for persons to be able to vote where they live, where they have children, and where they pay taxes. And we submit that the EU Directive 94/80/EC states very unequivocally that the right to vote is to be considered a corollary of the right to move and reside as enshrined within the treaty.
And did the European Court of Justice ever say something like that?
Your Honor, it is submitted that the European Court of Justice, in relation to voting rights for Netherlands nationals, in the case of Eman versus Servinger, the court outlined that by restricting voting rights to Netherlands nationals and outside of the Netherlands Antilles, there was no sufficient justification for doing so, and therefore this was held to be a breach of of persons from the Netherlands Antilles their right to vote.
Yeah, two Arubans.
Yes.
Yes.
Thank you very much. With this being said, I shall segue into why this implied right, the breach of this implied right to vote, has led to a breach of the Article 7, the right to freedom from discrimination. We submit, Your Honor, that this test was outlined as a three-pronged test in Mary versus State of Barbados. There must be worse or less favorable treatment, it must be on the basis of nationality only, and finally, it must be not objective or reasonably justifiable. We submit that any CARICOM citizens from Commonwealth states would be able to...
You have 3 more minutes.
Thank you very much, Your Honor. citizens from CARICOM Commonwealth states would have been able to vote in Barbados by virtue of Section 7 of the Representation of the People Act. And this allows Barbadian citizens and Commonwealth citizens resident for 3 years in Barbados to be able to vote. However, unfortunately for Mrs. Bent, CARICOM citizens from non-Commonwealth states are unable to do so. And we submit that Mrs. Bent has satisfied every single requirement, whether it be the regulations, whether it be the Representation of People Act, and whether Section 7 or 8. And the only thing that she has not been able to satisfy is that she is not a Commonwealth citizen, nor a Barbadian national, a citizen. And we submit that this clearly means that the discrimination is on the basis, or the worse or less favorable treatment. The period of 4 years to vote must be on the basis of nationality only. And in relation to the objective and justifiable reason for this discrimination, this is the court in the case of Shanique Myrie outlined that this is for the opposing counsel, my colleagues opposite, to prove. However, we submit that it is unlikely to be the case, as we are not submitted that she should be able to vote on the same requirements as Barbadian citizens, but rather it is arbitrary to have a distinction between CARICOM citizens from Commonwealth states while CARICOM citizens from non-Commonwealth states. Your Honor, I shall now move into quickly to my last submission, which is that Barbados has breached...
Oh, you've got 1 minute, so you have to make it quick.
Yes, Barbados has breached its international obligations under the RTC. We submit, Your Honor, that this is clear by virtue of not just the existence but the application of the Representation of the People Act. This court in its appellate jurisdiction in the Ventos vs. Chief Electoral Officer case outlined that the administrative acts of the Chief Electoral Officer are to be considered the state practice indicative of the application of the provisions, which is necessary for it to be inconsistent with international obligations, as outlined in Tomlinson versus versus Belize and Trinidad and Tobago. We finally in conclusion, we submit that this has led to an egregious breach of Article 7 because non-Commonwealth citizens are unable to vote while Commonwealth citizens are. However, it's not just Article 7, it is also Article 8, as Commonwealth citizens from one of any of the 39 Commonwealth states outside of CARICOM would also be able to vote within the election, while Mrs. Bent and other Surinamese nationals would be precluded from doing so.
Right, we see the problem.
So,
what do you seek? What order do you seek?
We, on Your Honor, we seek 2 declarations, both outlining that Mr. and Mrs. Bent's rights under the revised treaty have been breached. And finally, we seek 2 coercive orders. One, that Mrs. Bent be registered to vote, and Mr. Bent may have his judgment registered. And the authority for this is TCR and TCR Guyana versus Cooperative Republic of Guyana. Right. If I be of no further assistance to this court, these are my submissions.
Thank you very much, Mr. Bridgewater. You can catch your breath now. While your learned colleagues your learned friends can respond. So, Mr. Thomas. You have too much material to get through. Where you had too little material, really. Yes, Mr. Thomas.
If it pleases this honorable court, I am Arthur Thomas, Senior Counsel for the State of Barbados, and we are firm in our submissions that the State of Barbados has not breached any of its obligations under the revised Treaty of Chaguaramas. Particularly, the State of Barbados has not breached Article 7, 8, or Articles 223, Sub-Article 2. I shall make submissions showing that based upon a theological interpretation of the revised Treaty of Chaguaramas, no right or principle exists supporting the recognition and enforcement of Mr. Bent's judgment, while my colleague shall make further submissions showing that the State of Barbados was entitled to refuse to register Mrs. Bent on the electoral list. Your Honours, with your leave, I shall proceed with my substantive submissions.
Yes, please proceed.
Your Honours, the revised Treaty of Chaguaramas is an instrument of international law, and therefore it is subject to the rules and principles of the Vienna Convention on the Law of Treaties. Particularly, Article 31, Sub-Article 1 provides that a treaty must be interpreted within the ordinary meaning of the terms, within the context, and in light of the object and purpose. Your Honours, this honourable court opined in Trinidad Cement Limited and TCL Guyana against Guyana, that the court should not place undue reliance on the literal interpretation. They further stated that the revised Treaty of Chaguaramas, which has created the Caribbean single market and economy, is primarily to facilitate the sustainable economic development and social transformation of the people of the region. Therefore, it is the state of Barbados' submission that the revised Treaty of Chaguaramas is primarily to facilitate the economic development between member states. The context, object, and purpose of the treaty is that of an economic treaty. My learned colleagues have in their submissions suggested that a generous interpretation should be used. But we would argue that such a submission is misguided and untenable with the principles of international law, and rather the interpretation that should be used should be in line with the intention or the context of the treaty, and not necessarily a generous interpretation of the terms themselves.
But are you restricting the objective of the treaty simply to economic objectives? Because Article 45 speaks about the member states committing themselves to the goal of free movement of their nationals. In the Shanique Mary case, this court indicated that the right to move freely applied to all persons, not just those who were pursuing economic activity. And then, of course, in the 2007 Heads of Government decision, they indicated a right to move and to remain for 6 months in order, they said, to give a sense of belonging. So are we still at the stage only of an economic arrangement, or have we moved beyond that somewhat?
Your Honors, we would submit that the intention of the treaty is primarily economic, and articles such as Article 45 only seek to further that intention by providing or allowing for the further integration of the people within the CARICOM space, and that we would argue that the right to movement doesn't necessarily involve the right to employment, but it has other economic consequences, such in relation to tourism and other transactions that may be done by.
But not all the tourists who come to these parts of the world feel a sense of belonging. They don't necessarily need to feel as if they belong to the region, and that's what the head said they wanted to foster, a sense of belonging amongst the members of CARICOM.
And we would submit, in furtherance of the economic objective, there needs to be an integration of the people, and a requirement of that would be for persons within the region to feel a sense of belonging to the region, and therefore they would provide a greater contribution to the economic development of the region.
So all things are measured in money, right?
Primarily in these circumstances, within the context of the revised Treaty of Chaguaramas.
Now, if you say primarily, that means not totally then.
We'd argue that there are some consequences within the treaty that may not necessarily touch and concern economics, but the thrust of the revised Treaty of Chaguaramas should be that of an economic treaty.
Okay.
Yes, it makes us all wealthier in the region and hopefully happier, I suppose.
Yeah, to promote the sustainable economic development of the
So when
region.
you're talking about interpretation in accordance with the scope of the treaty, this is where your point has weight, that it really we're thinking of the economic side of things rather than anything else.
Yes, Your Honor.
Yes?
But then the enforcement of a money judgment will make you wealthier and happier too, I would think.
Well, Your Honors, we would submit that within the context of the treaty, Article 223, Sub-Article 2, does not or should not include domestic judgments. We draw the court's attention to the words of Article 223, Sub-Article 2, which says that each member state shall, in its legislative procedures, ensure the observance of agreements to arbitrate and the recognition and enforcement of arbitral awards. Further to this, Article 211 states that the Caribbean Court of Justice has compulsory and exclusive jurisdiction over the interpretation and application of the treaty.
I don't think anything is controversial, sorry, about what you're saying, and they're not arguing to the contrary. What they're saying is not that you know, the actual wording in is it 2232 are engaged. What they're saying is the underlying principle is what is engaged. So if you engage them at the level only of the text of the provision, then you're not interacting with their argument at all. They're saying that it's really the principle which underlies that provision, which has been breached by Barbados, not the wording of the provision.
Yes, Your Honors, and respectfully, we would ask you to consider that the terms of the revised Treaty of Chaguaramas and the fact that in Article 26 of the agreement establishing the Caribbean Court of Justice, it speaks with reference to the enforcement of domestic judgments. And we would submit that in these circumstances, the revised Treaty of Chaguaramas has, by implication, excluded any right or principle supporting the enforcement of domestic judgments. If you take a closer...
Are they excluded? They don't, the treaty doesn't mention it, but I don't see how it excludes it.
Well, Your Honors...
It wouldn't make much sense either, because there are far less arbitral awards. There are far more judgments, money judgments.
Well, Your Honors, with a close examination of Article 223, one would clearly see that that article seeks to deal squarely with arbitration and other forms of alternative dispute resolution. It is entitled Alternative Dispute Resolution, and paragraph 1 of that article goes on to say that each member state shall promote the use of arbitration and other forms of alternative dispute resolution to settle commercial disputes between private nationals. Further to this, paragraph 3 of that article states, or makes reference to the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Our submission is that paragraph 1, conjoined with the reference to instruments of international commercial arbitration, would necessarily indicate that that article squarely deals with arbitration, and therefore any principle that may underlie Article 223 subarticle 2 should remain within the confines of the purport of the article. Our learned colleagues on the other side have submitted that the principle underlying Article 223 subarticle 2 is to secure access to justice via legislative approaches. But we would submit that such a submission is untenable, misguided, and outside of the ambit of the revised Treaty of Chaguaramas. To include or to accept my learned colleague's submission would be to allow a blanket principle which would allow for judgments that do not concern or touch any issues relating to the revised Treaty of Chaguaramas.
They're prepared to restrict it to commercial judgments, as I recall. Would that give you any comfort at all if the restriction was just to commercial judgments?
Well, Your Honors, even if it did concern commercial judgments, our submission is that that article squarely deals with arbitration and does not seek to deal with litigation. And to assist in that, in those submissions, I draw the court's attention to the wording of the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. And it says that an agreement to arbitrate is where parties resolve or agree to submit their disputes to arbitration to be settled by a selected arbitrator or to an arbitral bodies. It further defines in Article 1 of that treaty that an arbitral award is an award decided through arbitration by an arbitrator or an arbitral body.
I think we know the difference.
Yes, Your Honor, but respectfully, we would submit that within the confines of that definition and within the confines of the article and with specific reference to treaties and instruments of international commercial arbitration, that article only seeks to take into consideration the principles of international commercial arbitration, and therefore it cannot include the enforcement or recognition or enforcement of domestic judgments.
Yes, I think we understand your point there.
Furthermore, Your Honors, even if we were to stretch the principles and the terms of the treaty to include, to say that because it's a judgment between two CARICOM nationals, that it should fall within the ambit of the treaty, or under the jurisdiction of the Caribbean Court of Justice, we would argue or point or draw the court's attention to Article 214, which states or places an obligation upon domestic courts to refer issues relating to the interpretation and application of the treaty to the Caribbean Court of Justice. Now, we submit that since the court in Suriname, no doubt aware of its treaty obligations, did not refer this judgment or the issue that led to the judgment to the Caribbean Court of Justice, that the judgment has nothing to deal with or does not concern with any rights or obligations under the revised Treaty of Chaguaramas. And therefore, even upon a stretch of the terms to try and include a general or blanket approach of access to justice, the issue relating to the judgment, it can reasonably be assumed, does not relate to any issues under the treaty.
But neither do the arbitral awards mentioned in Article 2232. These are just commercial arbitrations.
But respectfully, Your Honor, our submission is that Article 223 encourages member states to pursue arbitration to settle commercial disputes.
Yeah.
And in pursuance of that, then in those circumstances, each member state should seek to ensure that those arbitral awards are recognized and enforced.
Mm-hmm.
So within that context, then it may not touch and concern issues relating to the revised Treaty of Chaguaramas. Also, Your Honor.
That's fascinating. So you are calling into aid Article 214, dealing with referrals to the court.
Yes, Your Honor.
And basically, it provides that where there is an issue arising in domestic tribunals touching and concerning the treaty, then there should be a referral to the court.
Yes, Your Honor.
So if there's no referral, your point is that, well, there are no issues touching and concerning the treaty. Is that?
Yes, that is our submission.
Of course, the court could be wrong. Domestic court in Suriname, I mean, it could touch and concern the treaty, but the court, for whatever reason, does not think that it touches and concerns the treaty. How do you respond to that?
Well, Your Honors, we have to make the reasonable assumption that the court in Suriname would understand or would know their treaty obligations. And in those circumstances, if it did concern an issue relating to the revised treaty, then they would have referred it to the Caribbean Court of Justice.
And then the court would refer it back, and the Surinamese court would have decided the case. That's how it goes. So in a case like that, that would make a difference when it comes to the enforcement of that particular judgment after a referral from the CCJ?
It is our submission that no, it would not make a difference.
Okay.
Because that would involve stretching the terms of the treaty to include domestic judgment, which it does not seek to provide for. Your Honors, we also like to point out that, interestingly, pursuant to Article 223, Sub-Article 3, it states that where a member state has implemented the United Nations Convention on the recognition and enforcement of foreign arbitral awards, then it shall be in compliance with Article 223, Sub-Article 2. I draw the Court's attention to the Arbitration Foreign Arbitral Awards Act, Chapter 110A of Barbados, which has implemented that treaty. And therefore, pursuant to that section, the state of Barbados is in compliance with Article 223, Sub-Article 2. And therefore, the state of Barbados cannot be in contravention of that article or any principle underlying that article. Furthermore, Your Honors, even if the only other way that the judgment may be enforced at community law is where it is a principle or practice that is widely accepted throughout the community, and that is pursuant to Trinidad Cement Limited against CARICOM. And we would submit that there's no evidence of an accepted practice or widely accepted principle for the enforcement of the recognition and enforcement of domestic judgments. So outside of the revised Treaty of Chaguaramas, within the community, there's no principle supporting the recognition and enforcement of judgments in favor of Mr. Bent. Your Honor,
Well, there is a principle relating to the recognition and enforcement. I thought you were going to say that there's no principle for the registration of the judgments. Now, I'm not sure what happens in Suriname, but certainly in all of the common law countries of the region, there is a procedure by which foreign judgments can be recognized and enforced.
yes, Your Honor. But the legislation
Yes,
in Barbados,
for registration.
as with other member states of CARICOM, would have the same effect to Suriname. And pursuant to that legislation, Suriname would be unable to register and thereby recognize and enforce their judgment in those jurisdictions. So within the community itself, there's no principle that Suriname can use in order to register, recognize, and enforce their judgment.
But all these methods, registration, recognition, it all comes down to a form of getting the judgment enforced.
Yes, Your Honor.
Correct? So those are just ways of doing it. And as far as I know, every CARICOM state has legislation, or at least law, which allows foreign judgments to be enforced. So if that is so, then if all the laws of all the member states have mechanisms to enforce judgments from another state, isn't that then a principle of CARICOM law? Do we all share that same principle?
Your Honors, we would submit that may be a principle within the domestic sphere of the member states, but it is not a principle that exists within the ambit of community law or within the ambit of the revised Treaty of Chaguaramas.
But if it is a principle in every state, then it's, I would say, a general principle. And a general principle of law is the source of international law, isn't that so?
Well, in those circumstances, it's a general principle to the registration and recognition of judgments that either come from a Commonwealth jurisdiction or from a jurisdiction with which there is a reciprocal agreement. In these circumstances, Suriname falls outside of those categories, and there's no principle at the community or under the revised Treaty of Chaguaramas that supports the registration and recognition of those judgments outside of that avenue. Your Honors, even if we are to accept that such a right or principle did exist, it does not then breach Article 8 of the revised Treaty of Chaguaramas. The state of Suriname, which is a civil law jurisdiction, cannot claim to have received less favorable treatment in this regard. We draw the court's attention to the existence of Haiti as a civil law, another civil law jurisdiction, and a member state of CARICOM, and also to civil law jurisdictions external to CARICOM. And our submission is that the legislation in Barbados would have the same or similar effect to civil jurisdictions within CARICOM and civil jurisdictions without CARICOM.
So in other words, because Haiti is being treated badly, it's okay to treat Suriname badly as well?
Your Honors, we would submit respectfully that Haiti is not...
2 minutes to finish.
Haiti is not being treated badly in this regard. It is not receiving less favorable treatment, and it cannot claim to be especially prejudiced.
Well, I thought the test was the other way around. I thought the test was whether better treatment was being awarded to a third state. And if better treatment is being awarded to a third state, then that better treatment has to be awarded as well to Suriname by virtue of the MFN principle. I don't think that has anything to do with lesser treatment to a third state, if you see what I mean.
Guided, Your Honor, but we would respectfully submit that the legislation has the same effect to civil law jurisdictions, and in those circumstances, Suriname cannot claim to have received less treatment than, say, Haiti or a third state, which is a civil law jurisdiction.
But you admit that they can say so in relation to, say, the UK or some other country?
Yes, Your Honor.
Okay.
Okay.
Your Honors, in closing, I would submit or respectfully ask of the court that, impress upon the court that to accept such a principle as my learned colleagues seek to suggest would be to go beyond the intention of the revised Treaty of Chaguaramas and would be to usurp the powers and functions of the Conference of the Heads of Government. And therefore, we would submit that pursuant to Article 223, sub-Article 3, there's no principle underlying it that supports the recognition and enforcement of judgments in favor of Mr. Bent. And we'd ask that the court declare and adjudge that the state of Barbados has not breached Articles 8 and has not breached Articles 223, but rather has been in compliance with Article 223. And if I can be of no further assistance to this court, I now end my submissions.
Thank you.
Well, thank you very much, Mr. Thomas. So, Mr. Monroe, could you please come forward? Yes.
Your Honors, if it pleases this court, I, Michael Monroe, appear as junior counsel on behalf of the state of Barbados in this matter. Your Honor, I will be making two principal submissions before this court. First, Article 46, and by extension, the Caribbean Community Skills Nationals Act, does not create within its expressed or implied parameters the right for community nationals to vote within CARICOM states. And secondly, in the absence of the existence of such a right, this court is constrained to find that Article 7 has been violated. With the leave of the court, may I commence my submissions?
Certainly.
Your Honor, a prudent or perhaps a preferred point of departure is to submit that we are in concert with my learned friend's submission when they submit that Article 7 is not a standalone provision. Your Honor, we submit that for Article 7 to have practical consideration in this court, it must hinge or be contingent on the existence of a more substantive right as contained within the revised Treaty of Chaguaramas. We further contend, and we are in concert with my learned friends, that this court has the jurisdiction on the basis of the judgment in TCL Guyana Limited, that it can imply rights as corollaries to the more substantive rights as contained within the RTC. Your Honor, however, where we no longer tango with my friends on the other side is where they contend that the right to vote is a necessary implication to the right of free skilled nationals to move within the context of the revised Treaty of Chaguaramas. Your Honor, might I draw this court's attention to Article 46 of the revised Treaty of Chaguaramas? Your Honor, Article 46 is titled the Movement of Skilled Community Nationals. Subarticle 1 provides a category of skilled nationals that would move within the region. Subarticle 2 further imposes an obligation on states to establish appropriate legislative and administrative arrangements to enable and facilitate the utility of Article 46. Your Honor, we submit that Article 46, when taken in light of the object, purpose, and the context of the revised Treaty of Chaguaramas, further seeks to enable the notion of economic integration. It seeks to enable this notion through the movement of human resources within the CARICOM space. Your Honor, my learned friends seem to suggest that in the absence of the right to vote, the right to skilled nationals to move within the CARICOM region would be rendered meaningless or considerably of less value. Your Honor, but for us to consider if this right is meaningless or considerably of less value, one would have to consider in the context of the revised Treaty of Chaguaramas, whether it would necessarily impair or compromise the free movement of skilled nationals within the CARICOM region. Your Honor, this court would have recognized in Carabel Douglas at paragraphs 24 and 25 that there exist three regimes under which nationals can move within CARICOM. The Article 46 regime is to enable nationals to move for the purposes of employment. Your Honor, we submit that the right to vote as a necessary corollary to the right to move does not impair or render meaningless the ability of skilled community nationals to move for the purposes of employment. Your Honor, we submit that the CARICOM, the RTC, does not necessarily inure the right of nationals to move for the purposes of residency, permanent naturalization, or even citizenship. What the RTC necessarily imposes or inure the right is a right to move on the condition that the nationals engage in legitimate economic activity. So therefore, once the national necessarily moves and enters the CARICOM state, it would have to subject itself to the national domestic laws in relation to enable that national to exercise the right to vote within that country. Your Honor, we accept that the right to vote can be considered an incident of moving within the respective CARICOM states. However, the right to vote is not a right that necessarily can be deemed a corollary to the right to move within the context of CARICOM. Your Honor, taking the rationale of this court in Carabel Douglas, where this court would have recognized and would have postulated that a necessary corollary to the right to the freedom of moving to provide services would be the right to move and to receive services. So therefore, in this context, we submit on that rationale that the necessary corollary that would give life to Article 46 would be the, yes, you can move for the right to seek employment, but the necessary corollary would be the right to move to give employment. And therefore, Your Honors, in that context, it would give life and utility to Article 46. What my learned friends seem to be suggesting is to color Article 46 with a socio-political brush. And that cannot
No, but sorry, is it that they are doing that, or is that the heads have done that? Because I recited to you earlier some of the things that the heads have said, which seem on the surface anyway to go beyond a strict economic arrangement. They talk about, for example, the desirability of people moving amongst the countries of the region and the right to stay for at least up to 6 months to give a sense that they belong to the community. So wouldn't you say that that socioeconomic brush that you speak of is being wielded not by your opponents, but in fact being used by the heads of government? They are the ones who want to create this sense of belonging.
Yes, Your Honor, I thank you for the question. The context in which persons are allowed to move for the 6-month period is under for non-employment purposes. But this court is constrained with examining whether the right to vote would be a necessary corollary in the economic sphere of moving for economic purposes.
But if they can move for 6 months for non-economic purposes, and they are attributed that quality of belonging to the country, then surely if they are there for an indefinite period of time, then a fortiori, even more so, they would be entitled to have that sense of belonging to the country to which they have moved, surely.
Yes, Your Honor, I thank you for the question. And they would have that sense of belonging in the context of exercising the right to vote if they necessarily comply with the domestic laws that gives the right to vote. Your Honors, the Honorable Justice of the Caribbean Court of Justice, Winston Anderson, would have recognized in an article titled Fundamental Human Rights within the context of the Caribbean Court within the context of CARICOM, that fundamental human rights cannot be relied on by this court. It can only be relied on insofar as it provides clarity to the economic rights as contained in this treaty. And therefore, we submit.
Was he speaking judicially or not?
No, Your Honor, again, I would.
So why should we pay any attention to what he said then?
Was a lot younger and less well-informed then.
Your Honor, Justice Anderson, we would agree with my learned friends that Justice Anderson is a renowned jurist, and therefore his contentions have considerable weight, persuasion within the context of the CARICOM.
I'm glad there's a right of reply on the other side.
Yes, Your Honors. So therefore, when we consider the right to vote being a socio-political right, and we concede it is a fundamental right.
But there are economic implications, aren't there, as well? Because if you move to a new country to work there or to establish a business, you have an interest really in living in a crime-free area and hopefully low taxes. So if you wanted to protect your interests, develop your economic interest, you would like to vote for a party that was going to make your area more crime-free, and we would pay less tax than the other party would want.
Yes, Your Honor, I thank you for the question. And that would necessarily presuppose that the revised Treaty of Chaguaramas would inure and gives those rights. It does not give the right to life. It does not give the right to live in a crime-free environment. It does not give the right to be not subject to inhumane treatment. The revised Treaty of Chaguaramas necessarily gives the right to move for specific purposes. When the national moves within that particular jurisdiction, that national would be entitled to the rights as contained within the domestic sphere of that state. The revised Treaty of Chaguaramas is solely concerned under Article 46 for the purposes of moving for employment purposes.
Isn't it strange that, or awkward that Barbados gives this right to vote to nationals of other countries who do not have to be, these nationals don't even have to be skilled or whatever. They have to be in Barbados for 3 years, I think.
Mm-hmm.
So nationals from, and I'm reading the list, Pakistan, Ceylon, Ghana, Malaysia, Nigeria, Tanzania, Malawi, Singapore, even from Southern Rhodesia, which doesn't exist anymore.
Yes, sir.
All these people, if they are legally 3 years in Barbados and older than 18 and so on, they have a right to vote.
I thank you for the question, Your Honor.
And then a national from a CARICOM state, from the community, has no right to vote. That's
Your Honor,
at least awkward, is it not?
It's seemingly awkward, but Your Honor, the question would be, does the revised Treaty of Chaguaramas confer the right to vote? Mm-hmm. And our submission, based on the reasons provided, is that it does not provide the right to vote. And since it does not provide the right to vote, this court ought not to have due regard to the domestic legislation of Barbados. This court only shall have due regard to the domestic legislation of Barbados and deem it to be inconsistent with community law, where this court necessarily finds the right to vote at community law. So therefore, in the absence of this court finding the right to vote at the community level, then what or who Barbados decides to exercise their franchise is quite respectfully, not this court's business. Your Honor, this moves me to my next point.
Under our jurisdiction.
Yes, Your Honor.
Sounds better.
Yes, I apologize. I beg your pardon. Your Honor, this brings me to my third point. My learned friends on the other side would have relied on the EU directive, and they further relied on a case, Iman and Sanger. Your Honor, we submit that though the Treaty on the Functioning of the European Union provides some persuasion within the CARICOM context, it does not necessarily replicate itself with exactitude. And the reason being is that you cannot rely on the Treaty on the Functioning of the European Union when that treaty, one, in its preamble would have catered for the recognition of universal adult suffrage. Further, that treaty and that community union went further to recognize and actually manifest a document that inures the express right of European nationals to vote within the European community. In the CARICOM context, we do not have an equivalent or similar document that gives express recognition of that right. And lastly, Your Honor, the European Union subscribed to the notion of supranationalism, and therefore any directive or any directive issued by the European Commission would have direct domestic legal incidence within the states of the European Union. In the CARICOM context, there is no equivalent supranational institution that has the authority to determine that the right to vote exists at the community level. And even if there were a supranational institution with the similar characteristics, then owing to our subscription to the notion of intergovernmentalism, then the CARICOM state necessarily would have to incorporate that law into its domestic sphere. Your Honor,
the point is more that this right to vote is the right to vote for the European Parliament. We don't have a Caribbean Parliament.
Precisely, Your Honor.
But there is not in any document, as far as I have seen, a right to vote when you are in another member state, to right to vote for the Parliament of that other state.
Precisely, Your Honor. Precisely.
Yeah.
And we therefore ask this court that we have the fear and apprehension, by way of analogy, that the effect of this court declaring that the right to vote exists at the community level, let us consider that the CARICOM as a body is characterized by the notion of intergovernmentalism. What my learned friends are submitting is that this notion of the right to vote would necessarily infuse a notion of supranationalism. And we submit that if the immune system of CARICOM is intergovernmentalism, we cannot infuse supranationalism, which the immune system ought to reject. Your Honor, I see that my time has expired, and I would ask the court for a few seconds just to wrap up.
You can have 2 minutes to wrap up in view of the amount of questioning you've had.
Yes, Your Honor, I thank you. Much obliged. Your Honor, my last point before I ask this court for a relief sought is that the state of Suriname, their submissions seem to suggest that the revised Treaty of Chaguaramas should be treated as a constitution. And why I say a constitution is because within the domestic sphere, a constitution is treated as a living instrument. And therefore, the rights and obligations that inures to states evolves over time. Your Honor, we submit that rhetoric, that characteristic, cannot necessarily obtain within the international context. A treaty is not a document that evolves over time. A treaty is a document that represents the manifestations of the compromises that states were willing to make. And therefore, for us to go outside the context, for us to go outside the express parameters of the treaty would be us compromising the faculty of states. And therefore, Your Honor, the CARICOM states only can confer the right to vote on nationals if the CARICOM states necessarily cede their sovereignty in that regard. Your Honor, we ask this court to adjudge and declare that failure or a refusal of Barbados to register Mr. Brent's judgment does not contravene Article 8 of the revised Treaty of Chaguaramas. Further, Your Honors, we ask this court to adjudge and declare that failure of Barbados or a refusal of Barbados to register Mrs. Brent on its electoral list does not contravene Article 7 of the revised Treaty of Chaguaramas. If I may be of no further assistance to this honorable court, that is the extent of Barbados' submission.
Right, thank you very much, Mr. Monroe.
Thank you, Your Honor.
So now, Ms. Phillips, you have an opportunity to reply for 5 minutes.
Your Honor, my junior counsel is the one who will be giving the rebuttal, so he will reply.
Fine, I'm happy with your delegation then. Yes, after all, you've done your 20-minute slot. He's only done 15, so you might as well do the other 5.
May it please this honorable court, I shall now embark on a response. But prior to, I will first address a question that was posed to senior counsel that was to be addressed in the response. In relation to the question as to whether an appeal would cause or prevent the enforcement or registering of the enforcement of the judge or registering of the judgment in Barbados, we submit that Section 8.3 of the Barbadian Act clearly outlines that an appeal or the pending appeal should not prevent the enforcement from being the judgment from being registered to be enforced. Furthermore, a very respected jurist by the name of the Honorable Justice Winston Anderson clearly outlined in his book, The Caribbean Private International Law, that the common law, even though there is no restriction on enforcing or registering and enforcing a judgment that is pending appeal, the courts will find it prudent to do so. However, we submit that prudent to do so as to not waste the court's time or be inefficient. However, Your Honor, we submit to this honorable court that despite this hesitation by the courts, it does not preclude outright, neither the common law nor the statute preclude outright the registration and enforcement of Mr. Ben's judgment. Starting the rebuttal, Your Honors, our learned colleagues opposite spoke to that a treaty should be interpreted textually only. We submit that Article 5 of the VCLT outlines that the VCLT applies to constitutive treaties, which our opposing colleagues opposite clearly outline that the revised Treaty of Chaguaramas is. And we submit that this treaty should be interpreted teleologically, that it should be interpreted with due regard to the object and purpose of the treaty. And this was elucidated in the book of Richard Gardner's Oxford Guide to Treaties, which discusses and opines that it is about the object and purpose of the treaty when reading the provisions. Your Honor, the first counsel
Did we say anything about that in any of our judgments as to how the treaty ought to be interpreted?
Your Honor, it is submitted that this court has outlined that the treaty should be interpreted in conjunction with its object and purpose. And this was outlined in the case of TCL and TCL Guyana, where it outlined that the object and purpose of the revised treaty is to form a collectivity of CARICOM states, both and allow for social and economic development. And this segues into our next rebuttal point.
I seem to remember that was criticized by Professor Winston Anderson, as he then was.
When he was young and alert.
Your Honor, senior counsel for the state of Barbados outlined that MFN should be the comparator for the most favored nation treatment under Article 8 should be other civil jurisdictions, and we submit that this is flawed. Article 8 clearly outlines that the appropriate comparators are other third member states as well as third parties. Therefore, it is appropriate to compare the treatment that is meted out to citizens of Suriname and compare them to the treatment meted out to citizens of Jamaica, and we can clearly see there has been worse or less favorable treatment in that regard. Moving on to the second speaker, Your Honor, he spoke about the object that the revised Treaty of Chaguaramas is limited to economics, and that by allowing for an implied right to vote, you are providing a socio-political splash. Your Honor, it's submitted that it is not limited to economics, although we have outlined that the right to vote has economic ramifications. But further, we submit that it's about a sense of belonging, and as we outlined in TCL, it's about creating a collectivity of CARICOM states, Your Honor. And we submit that he said that the European Union is not a good comparator because of all of the level of integration it has undergone. But we will bring this court back to a time in 1957 with the signing of the Rome Treaty, which was only about economic integration for European states. And we submit that the Schuman Declaration of 1950 outlined that development of the Union will not occur all at once, nor will it occur under a single plan, Your Honor. However, it will be through concrete steps achieving de facto solidarity. And we submit to this honorable court that that is what this court will be doing by finding the implied right to vote, creating a concrete achievement towards the de facto solidarity, towards the collectivity of CARICOM states that this court outlined was the object and purpose of the revised treaty.
Schuman, that was Europe, isn't it?
Yes, Your Honor.
Little different from here.
Yeah, yes, Your Honor, but we submit that he said this even when the European project was at its beginning, when it was just about 5 states dealing with steel and coal, Your Honor.
Yeah.
And it has blossomed into a union far greater than anyone contemplated. And we submit that the revised treaty, although it is in an economic integration now, can blossom as well.
But that effort is suffering some difficulties now, is it not?
Your Honor, it is submitted that that effort is actually just being, a new wind has gone under the sails of CARICOM. We submit that by the protocol of contingent rights and how quickly the CARICOM states has signed on to this to provide additional enforceable rights, as well as how this new movement by the CARICOM heads of government, that is less talk and more action. We are seeing more things coming out of these sittings of heads of government, and we submit to this honorable court that this movement to integration has started once again, or is now going forward once again.
Right, well, thank you very much, Mr.
Thank you
Bridgewater.
very much.
Thank you. Well, I think we will be back in 10 minutes, so we'll just adjourn for 10 minutes and then come back and give our judgment on the moot, and Justice Anderson and Justice Witt will give their brief judgment on the right to vote point and the enforcement of judgments point. So we'll adjourn now for 10 minutes.
All rise. Judges of the Caribbean Court of Justice.
Can everyone please take your seats? Thank you.
Right, well, we're now coming to the interesting part, but before we make any final decisions, as with all the mooting sessions, we first of all make a comment on the two mooting teams that appear before us and decide whether there's a winner or a loser or a tie or what have you. So I'll just briefly comment on the mooters that we've just heard when we had Norman Manley Law School mooting against the Hugh Wooding Law School. And so we started off with Ms. Phillips as senior counsel and Mr. Bridgewater as junior counsel. They both had a problem, we thought, with organizing their material to fit it into the time. Perhaps a little too much of Ms. Phillips' material wasn't so relevant, but she was quite good in developing a fair pace in her presentation, maintaining good eye contact. Then we had Mr. Bridgewater, who I thought we would all think gave quite an entertaining performance, very good charmer at times, but of course you had a lot of material that you wanted to get through, and you obviously were going too fast a pace, and you're beginning really to talk at us or shout at us a bit. So it was difficult for us to intervene, but I know you were well prepared, you had so much material there and you want to get it off your chest. But you really need a much more solid, measured approach, which of course is very clear in the two counsel on behalf of Hugh Wooding. So coming to Hugh Wooding, as I said, there was good solid presence there, both of them, good eye contact. They had good material, they were well prepared, and also, specifically referred to points made in the other side's skeleton submissions. So we found that as between the two mooting teams this afternoon that we've just heard, that Norman Manley, that Hugh Wooding Law School was the better of the two teams, which then means we have to look back at the other moots that we heard this morning and yesterday. But we had the benefit earlier of getting together to work out which was the best of those teams, so enabling us to come to a quicker decision today. And in the end, looking at the mooters we heard today and the mooters we heard yesterday, we decided that the runner-up. I leave that in suspense for a moment. Because, of course, I'm forgetting, you haven't heard the judgments on the points of law. We have the enforcement of judgments. I think Justice Witt will deal with that, and then the right to vote, Justice Allison will deal with that. They're eager to get on with that, so I'll let them get on with it. Who would like to go first?
Well, let me start here. But before I go into the matter, just a few remarks that might give an interesting light on this case. This was about Mr. Boston Bend. Mr. Boston Bend was actually a historical figure. Probably only the Surinamese students might have known that. Boston Bend lived in the 18th century. He was born in Africa, but became a slave in Jamaica. In Jamaica, he learned how to write and to read. He was then probably taken to Suriname, where he, after a few years, fled into the woods and joined the Maroons. There are several Maroon tribes still in Suriname. And he was the only one who could read and write. And so this Jamaican ex-slave was the one who negotiated with the Dutch colonialists a peace treaty, which seems very much the same as the peace treaties that were dealt with in Jamaica about 20 years before that. And I thought it is an interesting thing to know that already in those days, Jamaicans were making use of the freedom of movement, not going to Suriname, but that was not free, but once he was there, he freed himself and assisted the Maroons in Suriname to establish a peace treaty. And it was therefore quite amusing that in one of the moots, it was a Jamaican team that had to defend Suriname, as Boston Ben did in his time, and that the Surinamese lawyers had to represent Barbados against Suriname, which also shows that in this community and in community law, you are not bound to present your own country. It is about the principles that makes us to a community in progress, I would say. So now I will go to the issue that is before us. And of course, this is only based on the submissions that were made and the discussions here, and cannot be seen as any authoritative judgment of the court. But we have come to the conclusion that there is no express right to get judgments, civil judgments enforced, but there is indeed an implied right. There are underlying principles, not just one. There is the principle of access to justice, which also requires not only that you can go to a court wherever you are in the community, but that you can also enforce the results of that, and that you can enforce civil judgments wherever you are. There is also the rule of law, which is an important principle within community law. If you can get a judgment, but you cannot enforce it wherever you want it, that makes the law less effective. And the rule of law, the law can only rule if you can really enforce whatever is just. Then, of course, there is the fact that all the member states subscribe the principle that you should be able to enforce judgments from foreign courts, and of course, especially that should be the case if these judgments are from within the community. Article 2232 speaks only about arbitral awards, and to use that Latin word again, a fortiori, if that must mean that you should also have the duty as member states to at least have a mechanism to enforce each other's judgments. So that is a principle that seems to exist within the community. It is a necessary prerequisite for judicial cooperation, for the functioning of the internal market. It does not require that you have a harmonized procedure, although that would be ideal. But there must be, it must be considered a principle of community law that these judgments can be enforced. And then we get to Article 8. Article 8 says, well, once there is a right covered by the treaty, then you must give that right in the same way as you give it to others. Certainly to other member states, but also to third states. And it would seem that the legislation in Barbados makes provision for easier ways of enforcing judgments through registration than for others. And so the fact that Suriname is not privy to that kind of privilege, it could well be held that in that respect there is a breach of the treaty, and that a breach of Article 8, as the Surinamese judgments are not treated in the same way in principle as the judgments of other member states. It is also interesting to know that this is a case between states, and this was the first time that we had a case between states. It's not a case of Mr. and Mrs. Bend against a state, and therefore the outcome of such a dispute would be more a declaration than anything going much further, for example, in the form of orders. But it seems to us, within the limited knowledge that we have gotten through the submissions, that right exists, and that it seems that there is a breach of Article 8 of the revised treaty.
Thank you, Justice Witt. If I could take up where you left off by observing that this is a case brought by one state against another, which is, of course, first we're having a moot of this kind. But it's also a little bit ironic that the state bringing the action, Suriname, is really saying that Barbados has breached the treaty obligations by not allowing one of its citizens to vote in Barbados. I think that's a little ironic, perhaps poetic. So the facts are that Mrs. Bent, who is, of course, a national of Suriname, resided in Barbados for over 4 years, and but for her nationality, she would have been entitled to be registered to vote in the general elections of that member state. So the claimant state of Suriname is alleging that Barbados breached Article 7 by the refusal of its officials, the Chief Electoral Officer in particular, to register Mrs. Ben to vote in the upcoming general elections. The claimant state points to the fact that other CARICOM citizens who are Commonwealth citizens and who satisfy the residency requirement are allowed to vote in general elections, and they cite the case of Eddie Ventos against Chief Electoral Officer. They argue, therefore, that there has been a clear discrimination against their nationalist, national Mrs. Bent, in that she was not allowed to vote simply because she is a citizen from a Commonwealth country. Now, during the oral arguments, it was also suggested that by refusing to register Mrs. Bent as an elector, Barbados also breached Article 8. As you heard from my brother just now, Article 8 requires that member states should accord to other member states treatment no less favorable than that accorded to third states. So the argument goes that in according voting rights to Commonwealth citizens, but denying that right to the Suriname national, Barbados is according treatment less favorable to Suriname. There was a procedural problem in our interfacing with this ground because the memorials, the written submissions, were focused on a breach of Article 7 and not a breach of Article 8. Furthermore, there was no suggestion or no request that there be an amendment to the pleadings. On the other hand, there were some counsel for Suriname, notably Cave Hill and Hugh Wooding, who argued both for breach of Article 7 and breach of Article 8, and there was no objection from the other side. And therefore, given how closely these two articles function together, we decided that we would consider both together. So the first question was there a breach of Article 7? The objective of Article 7, as you would have heard repeatedly over the course of 2 days, is to prevent discrimination between the nationals of the receiving state and the nationals from other CARICOM countries. Now, that discrimination which is prohibited is of course prohibited in relation to matters within the scope of the treaty. So in order to establish a breach by Barbados, Suriname had to establish two things. First of all, that there was discrimination by Barbados on the basis of nationality alone. And secondly, that that discrimination fell within the scope of matters covered by the revised treaty. We are of the opinion that the refusal by the Chief Electoral Officer to register Mrs. Bent to vote amounted to discrimination based solely on her nationality. It is very, very clear that Mrs. Bent had satisfied the residency requirement. The only reason that she was not, in fact, allowed to vote was that she was, in fact, not a Barbadian and not a citizen of a Commonwealth countries. Barbadians are allowed to vote. Mrs. Bent resided in Barbados for a considerable period of time, and she was nonetheless not allowed to vote. If she resided for another 20 years without changing her status, then she would not be allowed to vote. So we thought that there was discrimination there. Because the discrimination was clear, we didn't think it was necessary to examine those cases in which we had looked at how we measure whether discrimination exists or not. And one of the things we noticed is that some of the mooters went some distance into that question, and we didn't think that that was necessary because it was very obvious to us that there was a breach. There was a breach in terms of discrimination based on nationality only. But of course, the more difficult question was whether that discrimination fell within the scope of the treaty. And this, as I said, is a much more complex and involved question. Several arguments were deployed to convince us that the right to vote fell within the scope of the treaty. Some mooters, I beg your pardon, some counsel mentioned that she had lived and worked in Barbados and she had paid taxes over a certain number of years and so on. We didn't find that argument particularly convincing because, of course, working and paying taxes, residing, etc., is not necessarily tied to being within a community. People do this all the time. They go to places, they work, they contribute to the society, but they're not allowed the right to vote. So we didn't think that the right to vote necessarily fell within the scope of the treaty simply because she was residing and working in Barbados. Another argument put forward was the freedom of movement, that all of our skilled nationals, in effect, in the Caribbean, have a right to move between the countries of the region to seek employment. Others have the right to provide services and so on. And therefore, the question of freedom of movement was a more difficult argument for us to deal with because it could be implied that within that realm of the freedom of movement is insinuated the idea that persons who move and who remain, who take up root and so on, ought to have the right to vote. So we were detained by this for some time, but in the end we decided that the voting right did not come within the scope of the RTC. It is well known that the framers established the single market and economy as an economic space to encourage economic activity. We didn't think that we could possibly stretch that to include political rights such as the right to vote. We did take into account the fact that they had recently concluded a protocol on contingent rights. And of course, if they wished to include the right to vote, they could have done so in that protocol. It may be that at some point in the future, they may see it fit to include such a right, but they have not done so, and we did not think it was within our place to usurp their function. I wouldn't say it was none of our business, but it was just not within our sphere to do that. We looked at the question of a breach of Article 8, And again, we agreed that it was quite clear that Mrs. Bend had been accorded less favorable treatment than accorded to nationals of third states. That was not a difficulty at all. But the difficulty, once more, concerned the question as to whether that less favorable treatment fell within rights or concerned rights covered by the treaty. So we're back to where we started as to whether right to vote could be implicated in the treaty provisions. We were very impressed by a lot of the creative arguments that were pressed upon us. But in the end, we came to the view, perhaps reluctantly so, that we did not think that the right to vote was in fact a right covered by the treaty. There's obviously no express right in the treaty to vote, and we were regaled by the argument that there could have been a corollary right or an implied right or a contingent right. Now, those terms are used fairly loosely. The one that we are most familiar with is the corollary right, and we spoke to that in the case of TCL against Guyana. But the corollary right, of course, is a mirror of an obligation placed upon the state. And we saw no indications here that there was any primary right, if you will, from which a secondary right to vote could have been inferred. So, with some reluctance, because we know that this matter has been agitating the community for some time, my brother mentioned, was it in 18 something that Bent went to Suriname. So I've been struggling with this for a little while, but it seems as if we may have to struggle for a little while longer. The decision of the court, therefore, is that we will refuse the applications made by Suriname. There will be no order as to costs on this occasion, and we commend counsel for their courageous and at times quite brilliant interventions. Thank you.
Right, well, thank you very much. Just to remind you, of course, this is not a precedent to be utilized. After all, we haven't had the benefit of a whole day's argument from 4 silks. And of course, there only are 3 of us here. There are another 4 that could outvote us. So that then comes to the suspenseful moment when I'm going to declare who was second and then who was first. Well, the runner-up is actually the University of Guyana, which therefore becomes the winner of the academic institution prize. But the shield winner is the Hugh Wooding Law School. Mr. Thomas and Mr. Monroe put on very good performances from which all of us can learn, I think. So thank you very much for your efforts. So now I think we come to adjourn so that we can have the prize ceremony organized. So.
All rise.
No. Okay, thank you. Thank you very much. President. Honorable Chief Justice, Mr. Justice Ivor Archie, Judges of the Caribbean Court, His Honor, Mr. Sunil Sukraj, Chairman of the Environmental Commission of Trinidad and Tobago, Dr. Monica Davis, the Honorary Consul for Bahamas, the Right Honorable Sir Charles Dennis Byron, former President of the Caribbean Court of Justice, the Honorable Mr. Justice Carl Singh, former Chancellor of the Judiciary of Guyana, Ms. Miriam Samaru, the Principal of the Heward Law School, students and advisors of participating schools, and all our very distinguished guests, the media. It is my very special privilege to begin the part of the day's proceedings in which prizes are awarded and certificates are distributed, the award ceremony. We begin with certificates to the Moot Registry. And Deputy Registrar, Ms. Misha Ann Kelly, if you would be so kind as to assist. Amanda Mohanlal. Chelsea Nanlal. Jesse Guy. Ajay Ragunanan, Denisha Monroe, Mishan Prasad, Adia Tilak Singh, Samantha Frost, Devika Kapildeo, thank you very much, Deputy Registrar. We now present certificates and medals to the Normal Manley Law School, Jamaica. Danae Phillips, Ty Bridgewater, Zachary Phillips. Thank you very much, Madam Registrar. And we move on to Anton de Kom University, Suriname. Shaista Nabibat, Ratna Patandan, Lucretia Olickfield. Oh yeah. Sorry. University of the West Indies, St. Augustine. Wesley Ramnarayan. Kavita Ramadar. and Nefta Francis. Thank you very much, Madam Registrar. University of the West Indies, Mona, and I'd like to invite the Honorable Sir Dennis Byron to assist us. The Right Honorable Sir Dennis Byron. Samantha Grant. Richard Goldborn. Cheyenne Hilton. Thank you very much, Sir Dennis. Now we move to the University of the West Indies, Cavell, and I would like to ask Mr. Justice Andrew Burgess to assist us. Rashid Lee. Cameron Porter. And Kamal Grant. We move to the University of Technology, Jamaica. And I'd like to ask the Honorable Mr. Justice Dennis Barrow to assist us. Daniel McCullough. Jessica James. And Ainsworth Levi. No, not yet. We have university. Okay. Thank you very much, sir. And we now move to the University of Bahamas. And I would like to ask Madam Justice Rajnath Lee if she would assist us. Kashina Thompson. Randa Bodhi. And Lashan Martin. Ma'am, and if I can ask you to hold just one moment for Harold Adepora from Anton de Com University. Thank you very much, ma'am. And now we move on to those awards, and I would like to ask if the Honorable Chief Justice, Mr. Justice Ivor Archie, would be so kind as to assist us in presenting the award to the second place team and the plaque to the winning school. University of Guyana. Ian Miller, Cassandra Jaikaran, and Shaniza David. And if you just hold to receive your medals and certificates from Chief Justice Ivor Archie, Rian Miller, Cassandra Jaikaran, Shaniza David, and okay, thank you very much. For the winning team, we would like to ask the Honorable Mr. Justice David Hayton if he would be so kind as to make the presentation of certificates and medals to the winning team. Hugh Wooding Law School. So it's Arthur Thomas, Michael Monroe, and Roger Hector. Just hold here, please, because you have something else to get. Michael Monroe and Roger Hector. Thank you very much, sir. And to present the CCJ Challenge Shield to the winners of the CCJ Annual International Law Moot, we ask the President of the CCJ, the Honorable Mr. Justice Adrian Saunders, assisted by Registrar and Chief Marshal, Mrs. Jacqueline Graham. Hugh Wooding Law School. There's lots of opportunity for photographs in the next few minutes. Thank you, Registrar. I now invite the President of the Caribbean Court of Justice to address us.
Thank you very much, Colonel Farrell. And the order of protocol having already been established and our distinguished personages having been suitably recognized, would you permit me just to recognize the Chief Justice, my colleague judges, Mr. Dennis, and all the other distinguished guests here today. We wish to thank you all for accepting our invitation to the concluding part of this annual Moot. And what a round of competition it has been. Over the last 2 days, these law students have argued their cases with skill, with passion, before some of the highest judges of the region. I was only able to listen to 1 or 2 of the presentations, but I was extremely impressed with the advocacy that I saw displayed. And this must have been the norm, because Mr. Justice Burgess went out of his way this afternoon to say to me how awed he was at the quality of the presentations. And the quality of the presentations is measured, I think, in some respects, by the fact that the judges showed no mercy. I can tell you that they treated the mooters in the same way they would treat experienced counsel. So, by the way, let's have a round of applause for our judges. So that if this experience does not sharpen up your advocacy skills, then I'm not sure what else will. You've all done extremely well, and I ask for a round of applause for all our participating teams. I do not for a minute take for granted all the various elements that must be assembled to secure the participation by the various teams in the Moot. Necessary funding had to be obtained, your travel and accommodation had to be arranged, long hours would have been spent by teaching faculty and guiding and preparing each of the teams. It would be remiss of us if we did not also extend our appreciation to all those behind the scenes who made your presence here possible. And please, for a round of applause for all such persons. As I indicated yesterday at the opening, for us at the CCJ, this Moot is a period of high activity at the court, as each of our units is mobilized and deployed to support the mooters and the competition, and to give the students the best practical courtroom experience that they can have. So we've had 6 CARICOM countries, 9 law institutions, and 27 students participating in the Moot this year. I trust that even as you engaged in stiff competition with each other, you made use of the opportunity to forge new friendships and to expand your network of contacts. I remember at lunch yesterday urging one of the teams, I think it might have been UTech, all of whose members were visiting Trinidad and Tobago for the first time, to make sure and get some doubles this morning or tomorrow morning. And I hope they followed my advice and so sampled just a taste of the unique Trinidad roadside cuisine. Of course, we don't organize and host this event out of pure altruism. We also have an interest of our own. Over the years, we have deliberately selected as the topic for the Moots challenging but practical questions likely to arise in the operation of the CARICOM single market and economy. And we take very careful note of your approaches to these questions and your responses to them. So the Moot therefore plays a role, however modest, in supporting our responsibility to interpret and apply the revised Treaty of Chaguaramas. As I speak to people of all walks of life throughout the region, it is so very clear to me that there is a huge gap, a chasm, between popular perceptions about the Caribbean Court of Justice on the one hand and the reality of the court on the other. These perceptions are not based on actual knowledge about the court about its processes and practices, they're largely premised on wrong assumptions. And so we in the court have an interest in having more people, particularly young people, obtain first-hand knowledge about the court so that they can savor for themselves what Belize and Guyana, Barbados and Dominica are experiencing and what the rest of the region is missing out on. In one of the speeches I made last year, I noted the fact that after 50 years of political independence, in 8 of our common law CARICOM states, the laws that are proudly made by legislators elected by the people of those states are ultimately interpreted by a British institution, staffed with British judges, all of whom reside in Britain. And this after these same CARICOM states over 15 years ago established this court precisely to serve that purpose. And after the United Kingdom voted to separate itself from the rest of Europe, partly because the English did not want their laws to be interpreted by European courts. In my speech, I referred to this state of affairs as an anomaly. But for many of us, it is more than an anomaly. It is a painful embarrassment linked directly to the perception we have of our abilities as a people and our level of self-confidence. On this score, Colonel Farrell, our Chief Protocol and Information Officer at the court, who was the chair of these proceedings, recently reminded me of the words of a poem called Love After Love by the St. Lucian Nobel laureate Derek Walcott, one of the finest writers of verse in the English language. Love After Love has been described as an unusual poem in that it concentrates on loving the self, the inner self, following the breakdown of a relationship. Its main theme is that of becoming whole again through self-recognition, a kind of healing that works by self-conscious invitation. And Colonel Farrell thought, and I gladly agreed, that some of the words of this poem were quite appropriate to describe the anomaly of which I just spoke. And this is what Walcott wrote. The time will come when, with elation, you will greet yourself arriving at your own door, in your own mirror, and each will smile at the other's welcome and say, sit here, eat. I have absolutely no doubt that the day will come when the self-belief of the people of the entire region would lead us to greet ourselves in our own mirror, to smile at our own welcome, and partake of the fruit of our own labors. And so I trust that through this engagement, each of you students will not only better understand the revised Treaty of Chaguaramas and the CARICOM single market and economy, but that you would also become advocates for the repatriation to the Caribbean of all the region's final appeals. I cannot conclude my remarks without extending to the Honorable Mr. Justice David Hayton my appreciation for the enlightened leadership that he has brought to the organizing of this annual International Law Moot hosted by the court. He has been associated with the Moot from its inception, and as he retires later this year, the court expresses its deepest thanks to you, David, for your unstinting service. The Mooters will recall that in your absence yesterday, I asked them to give you a round of applause. I ask them now to give you a more thunderous one in your presence. And I would also now like to ask the Registrar and Chief Marshal, Ms. Jacqueline Graham, to present to you a token of the court's appreciation, following which I would invite you to make a few remarks. Thank you very much.
Well, thank you very much. I really appreciate it, but I must say I've enjoyed these 11 moots going back to 2009. We thought it'd be a good idea to get the younger generation more au fait with the law that could be developed within the revised Treaty of Chaguaramas, because the treaty is very much a skeleton structure which needs to be fleshed out. And also thought we could get them to know a little about the CCJ, since not so many people seem to be aware of what we were doing. But in those early days, it was difficult for the mooters, because of course there were relatively few original jurisdiction cases, and we were still awaiting the book by David Berry on Caribbean integration law, which of course has been of great assistance. But we thought we'd also get the brightest lawyers involved, because to moot, you've got to be very bright, very thorough, very self-confident, and have a relatively thick skin, I think, which is really the requirements for a good silk. Mooting in general, of course, brings out the best, because you really got to be exceptionally thorough. It's not like an ordinary supervision or tutorial or whatever, where you can hang your head or keep quiet. You really have to be there ready to answer any question put to you, and particularly in an arena like this, can be a bit terrifying, for fear you don't really know what the answer is. Though I've noticed one or two people have developed the technique of saying, "Oh, could you please repeat that question again?" to give you a bit of time, or "Thank you very much for that good question," to give you a bit of time, when you're really thinking, "Oh my God, I don't think of that question, you're so and so." But you learn these tricks as you go along. And then the question really is developing knowledge in the original jurisdiction, which of course is rather different from dealing with domestic law. International law and its interrelationship is a tricky area. And so it's been necessary to try and bring people up to speed with the right approach, and become more knowledgeable with regard to the revised Treaty of Chaguaramas. Because, as I say, it has a long way to go to be properly developed, because it is just a skeleton structure. And it's the new generation of up-and-coming lawyers who are going to be pushing that, I think, because you find that the only way that these conventions develop fully is through the private sector bringing actions and pushing things, because states don't like to sue each other, again, for fear of all the embarrassment that could occur. So the idea behind these moots has been to develop greater knowledge and help prepare a new generation coming through. And certainly listening to the moots over the years, the mooters have become better and better, more knowledgeable, more sophisticated. And I think that's reached its height today. And not only was the caliber of legal points of high standard, we did, in fact, I think, have two very good mooters who really showed you how to have a good solid presence, eye-to-eye contact, and how to respond fluently to questions that were put. So that this is becoming a bit of a showpiece. It is streamed, so it will help develop further and better knowledge and better advocates in due course. And so I'm delighted, really, that I believe in the court at a time when I know it will go on from strength to strength, because it's got such momentum that we've developed over the last few years, helped by my colleagues setting the moots. I'm not a specialist in this particular area myself, so I've been very dependent upon colleagues producing some interesting moots. And of course, today we had a very interesting one, in that quite often we deal with technical areas, whereas here we were going into new areas, seeing to what extent you could have derivative or implied or correlative rights that were derived in trying to get to grips with this new language that would have to develop in our judgments in due course. And of course, also one feature of the moots as they develop and more teams that come along is the more we need to depend upon the services of all the court staff. So incidentally, in dealing with these moots, we've improved the efficiency of the staff as well. And hopefully, I think, got some good camaraderie going amongst them, as well as, I think, the mooters, knowing that they've been over the front line to develop the camaraderie of those going into the front line into battle. And they've had to battle, and they've battled well over these years. So on that note, I think I'm leaving everything in good nick. It'll get even better, I think. Andrew Burgess will be taking over from me, and we'll be looking at ways of tweaking and improving it even better. Or is that possible? Anyway, thank you very much.
Thank you very much, Mr. Justice Hayton. It must be a very poignant moment. We have concluded the award ceremony, and now all teams are reminded that they must proceed with their team liaisons to courtroom 2 for photographs, and all our guests, you are kindly invited to the second floor training and conference room. The ushers will kindly assist you. Have a good evening. Thank you.